Hello madam, we are from Tutorial 1 Group D and this is our Contract Law 1 presentation. Our group members consist of myself Amrita Kaur, Chen Mei Fen, Danya Srinair, Ho Yong Le, Niharine and Yasuda. And now I'll be passing it on to the first speaker.
So before delving into the issues at hand, let me briefly outline the facts of the case. In this case, Adam promised to pay 500,000 ringgit to his nephew, Suhaimin, as an incentive to marry Seri Devin, who is daughter of Adam's business competitor. So this promise was made with the intent of strengthening business alliances. However, Suhaimin was already secretly engaged to Seri Devin, and their wedding plans were set in 5 months. To honor his promise, Adam purchased a Ford Mustang for Suhaimin and formalized his commitment by signing an agreement. Later, Suhaimin requested that Adam sponsor a scholarship for his younger sister Yuna to pursue her study in France for 4 years. Yuna was only 16 years old at the time, and Adam agreed on the condition that Yuna would work for his company for at least 5 years after completing her studies. Suhaimin, as her guardian, signed the agreement on Yuna's behalf. But unfortunately, Adam's business faced severe financial distress, causing him to reclaim back the Ford Mustang and failed to pay the promised 500,000 ringgit. Disheartened by Adam's action towards her brother, Yuna initiated a legal action against Adam. And upon completing her studies, Yuna decided not to work for Adam's company, citing its financial instability. So moving on to the issues. In this case, we identified 4 issues. The first issue is whether there is an intention to build a legal relation. This issue arises because Adam promised 500,000 ringgit to his nephew Suhaimin for marrying Seri Devin, not merely as a familial gesture, but as a strategic business move. So does Adam's act of purchasing a Ford Mustang, along with signing a formal agreement, indicate an intention to create a legally binding relationship? The second issue is whether there is a good consideration. So this issue arises because Adam promised 500,000 ringgit in exchange for Suhaimin marrying Seri Devin. So does this exchange of promises, which is Adam's financial reward for Suhaimin's marriage, is qualified as a valid consideration under the contract law principle? So moving to the third issue, can Yuna initiate legal actions against Adam, alleging that he had failed to honor the promises made to Suhaimin? So this issue arises because Yuna, disheartened by Adam's action toward his brother, attempt to sue him for failing honor his promises to Suhaimin. So can Yuna, as a third party to the contract between Adam and Suhaimin, initiate legal action for a breach of contract? Moving on to the last issue, whether the scholarship agreement signed by Suhaimin as Yuna's guardian while she was a minor is legally binding and enforceable upon Yuna. So this issue arises because Suhaimin, acting as Yuna's guardian, entered into a scholarship agreement with Adam while Yuna was still a minor. So is the scholarship agreement enforceable against Yuna, given that contract involving minors are typically void, or does it falls under the exception for scholarship? That's all from me. Now I'll pass to the next person.
I will now be discussing the authorities that we have used in decoding our first issue. In particular, we have chosen the case law of Carlyle against Carbolic Smokeball Company 1803. The facts of the case is that the Carbolic Smokeball Company advertised that they would pay £100 to anyone who used their smoke ball as directed and still contracted influenza. To show their responsibility and to show their commitment towards this promise, they also deposited £1,000 into the bank. Mrs. Carlyle, who saw this advertisement, then purchased the smoke ball and decided to use it as directed in the advertisement itself. However, she then contracted influenza. When she found out that, oh, I have now contracted influenza despite using the smoke ball as directed, she consequently brought a suit towards the Carbolic Smokeball Company to demand and claim her £100. However, in this case is when the issue of whether there was a legally binding offer arose. The court, however, held that the advertisement was a unilateral offer made to the public. The promise of £100 along with the deposit of £1,000 in the bank showed the company's intention to be legally bound. Mrs. Carlyle accepted the offer by performing the conditions stated in the advertisement, which was using the smoke ball as directed. No communication of acceptance was required in unilateral contracts.
In this situation, Idam promised to pay his nephew Suhaimin 500,000 ringgit as an incentive to marry his business competitor's daughter, Seri Devin. It is stated that this proposal is not a merely familiar gesture, but also a calculated move by Idam to potentially strengthen alliance and to gain an advantageous position within the competitive business landscape. Besides that, in adherence to his promise, Idam displayed unwavering commitment by purchasing a Ford Mustang for Suhaimin as a wedding gift and formalized his intention to be legally bound by signing an agreement with Suhaimin. However, Idam's business encountered severe financial distress coinciding with Suhaimin and Seri Devin's wedding. As a result, Idam's reclaimed the Ford Mustang and also failed to pay the 500,000 ringgit as he promised. Disheartened by Idam's action towards Suhaimin, Yuna initiated legal actions towards Idam, alleging that he had failed to honor his promise to Suhaimin. So, in order to discuss whether Yuna have the right to initiate legal action towards Idam, first we must identify whether there is a valid contract in the first place between Idam and Suhaimin or not. In order to identify the validity of the agreement between Idam and Suhaimin, we must first identify whether there is an intention to build legal relationship or not. In reference to the case of Khalil vs. Carbolic Smoke Bowl Co. 1893, the defendant Carbolic Smoke Bowl Co. has published an advertisement on the newspaper stating that they will pay £100 to any person who contracted influenza after using one of their balls in a specified manner and a specified period. They also stated that they had deposited £1,000 in a bank to pay for the reward. The court held that a reasonable man would construe from the money deposited that there was an intention to be bound. Lord Justice Bowen also stated how would an ordinary person reading the advertisement construe it. Was it intended that the £100 should, if the condition were fulfilled, to be paid? The advertisement says that the £1,000 is lodged at the bank for the purpose. Therefore, it cannot be said that the statement is nothing but a mere puff. Same goes to Idam in this situation. Idam promised to pay 500,000 ringgit as an incentive for his nephew to marry his business competitor's daughter, Seri Devin. And his act of purchasing a Ford Mustang for Suhaimin as a wedding gift to display his unwavering commitment to his promise shows that he has the intention to be legally bound.
Now, I'd like to talk about the authorities that we have used in decoding the second issue of our case. For this issue primarily, we have used sections from the Contracts Act 1950 and one example case. Alright, so let's dive right into it. Firstly, Section 10 of the Contracts Act 1950, which we have interpreted and understood in this manner, states that an agreement becomes a contract if it is made with the free consent of parties who are legally able to contract. Involves lawful consideration, has a lawful purpose, and is not declared void explicitly by the law. Next, we have also used Section 26 of the Contracts Act 1950, which we have interpreted in this manner. An agreement without consideration is void. Next, we have also used Section 2E of the Contracts Act 1950, which we have interpreted in this manner. In this act, unless the context indicates otherwise, an agreement is defined as every promise or set of promises that serve as consideration for each other. Now that we've wrapped up our legislations, let's go into our case, which is the case of Shadwell against Shadwell 1816. The facts of the case is that the defendant was the plaintiff's uncle. The uncle promised to pay the nephew 150 euros a year until the nephew's income reached 600 guineas, provided that the nephew married his fiancée. The uncle paid 12 installments but then passed away, and the payments then stopped. The nephew consequently sued his uncle's estate for the remaining payments. So in this case, the issue of whether the nephew provided consideration for the uncle's promise arose. It was held by Eric Chief Justice, who was the presiding judge of this case, that the performance of the marriage contract was consideration in itself. Even though the contract was made with a third party to the agreement, the uncle's promise was an inducement to the nephew to perform his contract. He said that the plaintiff had, by getting married, made a material change in his position and had induced his wife to do the same. They may have incurred pecuniary liabilities that would be a loss to them if the promised income was withheld. He recognized that marriage could be a benefit of interest to relatives, and so the uncle did derive a benefit from the marriage. Therefore, it was held ultimately that the marriage in itself was good consideration.
Now, we must identify whether there is a good consideration or not of the contract between Idam and Suhaimin. According to Section 2E of the Contract Act 1950, every promise and every set of promises forming the consideration for each other is an agreement. In addition, consideration is a necessary ingredient to form a valid contract. According to Section 10 Sub 1 of the Contract Act 1950, all agreements are contract if they are made inter alia for a lawful consideration with a lawful object. And according to Section 26 of the Contract Act 1950, an agreement made without consideration is void. In this situation, it falls under the agreement without consideration under common law, pre-existing contractual duty to third party. In reference to the case of Shadwell versus Shadwell 1860, an uncle promised to pay his nephew a certain sum if he married one Ellen Nicole. The nephew at the time of the promise has already engaged to marry Ellen Nicole. This raises the issue of whether the eventual marriage of the nephew to Ellen Nicole was sufficient consideration for the uncle promise. The court held that it was sufficient consideration as the marriage was benefit to the uncle, stating that the performance of an existing duty to third party is still a good consideration as there is a direct benefit obtained. Therefore, in this situation, the agreement between Idam and Suhaimin still contains good consideration. Although Idam promised to pay his nephew Suhaimin 500,000 ringgit as an incentive to marry his business competitor's daughter during that time, without knowing that Suhaimin has secretly engaged with Sari Devin for months, and in fact, they are having a wedding plans which is that set for just in 5 months. Because the marriage was still benefit to Adam, as stated in the situation that the marriage of Suhaimin and his business competitor's daughter Sari Devin can potentially strengthen alliance and also gain advantage position within the competitive business landscape.
Now, let me jumpstart to my first part of the presentation, which is the authorities and law. As per the slides, I have listed down 2 cases in there. The first case, which is Kepong Perspective Ltd against Smith, and the second would be Shanmugam against Francis. Now, let's have a look at the facts of the case for the first case. Schmidt, a mining engineer, decided to help a third-party man named Tan to obtain a mining permit. Tan, however, promised Schmidt 1% of the selling price of an ore. It's typically a rock or mineral that comes from valuable substances. As it was extracted, it was given as a consideration for his services in helping Tan getting the mining permit. Tan obligations under the agreement were later then transferred to Kepong Perspective Ltd. Schmidt sought to enforce the 1954 agreement between Tan and the Kepong Perspective. But the Privy Council decided that or held that Schmidt could not enforce the 1954 agreement because he was not a party to it. Schmidt, however, was successful in enforcing a separate agreement made in 1955, which he had directly entered into Kepong Prospective Ltd. In this case, it underscores the strict application of the privity rule, which means a third party without a direct agreement with the other parties cannot involve themselves or cannot enforce a contract. This case also emphasizes that only parties to the contract can enforce it unless there is a direct agreement between the third party and one of the other contracting parties. We have a clearer picture on the first case. Let's have a look at the second case, which is Shanmugam against Fraser. Now, in this case, the court reinforced the principle of privity of contract, which holds that only one party can sue for its breach. In this case, the plaintiff, not being a party to the contract, was absolutely denied the right to bring a claim for breach. This decision really emphasizes that only those who have directly agreed to the terms of the contract have the legal standing to enforce it or also to seek damages. The ruling also upholds the importance of maintaining clarity in contractual relationship, and furthermore, it also ensures that only involved parties can take legal action. However, exceptions such as third-party beneficiary contracts may allow non-parties to sue if the contract was made for their benefit. I've covered my first part of the presentation. Let's jump into the second part of my presentation, which focuses on the application. This presentation focuses on whether Yuna can initiate legal action against Adam, alleging that he failed to honor the promise to Suhaimi. Now, to address this, we will examine the privity of contract of doctrine, discuss its exceptions, and also analyze its application by using the two cases I have previously mentioned, which is the case of Kepong Prospective Ltd against Smith, 1968, and also Shanmugam against Francis. I will also provide an application section to tie this analysis to Yuna's situation. The general rule under the doctrine of privity of contract is that only parties to contract can enforce its terms. This principle was clearly articulated in the case of Tweedle against Atkinson, where the court held that a third party, even if a beneficiary, could not enforce the contract because they are not privy to it. This doctrine prevents strangers to the consideration or agreement from suing for enforcement. Now, similarly, a third party cannot have the liability imposed upon them under a contract which they are not a party. Now, by applying this to our question, Adam's business, which encountered severe financial distress, coinciding in Suhaimin and Sri Devin's wedding. As a result, Adam reclaimed the Ford Mustang and failed to pay the 500,000 he had promised. Disheartened by Adam's action towards her brother, Yuna initiated legal action against Adam, alleging that he had failed to honor the promises made to Suhaimin. Yuna, in this situation, cannot initiate legal actions towards Adam because she is the third party. The contract is between Adam and Suhaimin. So, Yuna is just a third party in this case. In earlier cases, in Shanmugam against Fraser, it was held that a plaintiff who is not a party to the contract cannot sue for the contract's breach. This can also be seen in the case of Kepong Prospective against Smith. Despite privity restrictions, Yuna may enforce the contract if Suhaimi created a trust for her benefit. Without such trust, Yuna must prove that Adam made independent commitments to her, otherwise her ability to sue is limited by the privity of doctrine. In conclusion, while the doctrine privity limits Yuna's ability to directly enforce the promises made by Adam to Suhaimi, the exceptions or independent agreements may offer potential remedies. The case of Kepong Prospective Ltd against Smith illustrates the critical importance of being a party to the agreement to secure enforceable rights. That is all from me, and that is all from my part. Thank you.
Now, I'll be presenting on the law and authority used for the fourth issue. To analyze whether it's legally binding and valid or not, we must keep in mind that Yuna was only 16 when this contract was made. The first provision that we're looking to is Section 2 of the Age of Majority Act 1971. This provision states that, subjected to Section 4 of this Act, the minority of males and females in Malaysia shall cease when they reach the age of 18 years old, and then they shall be considered the age of majority. The second provision we shall be looking into is Section 2A of the Contracts Amendment Act 1976, which outlines the definition of a scholarship agreement. So a scholarship agreement is made between an appropriate authority and the individual receiving this loan, bursary, sponsorship, scholarship, or appointment to study of a course. It may happen while they are on leave or without pay, and it also may come with privileges from that appropriate authority or any other body or organization. Lastly, we'll be looking at the provision of Section 4A of the Contract Amendments Act 1976, where it states that on the grounds that the scholar enters the contract without attaining the age of majority, the contract shall not be invalidated. Next, I'll be discussing several cases pertaining to this issue. The first case is the case of the Government of Malaysia against Gurcharan Singh and others. In this case, the defendant was sued for the amount of 11,500 by the plaintiff as a cost for an education for him to qualify for and apply for the appointment as a teacher. Keeping in mind that he entered into this contract when he was a minor, the court, upholding the principle set out in the case of Mohori Bibi, rendered the contract void since he entered into it when he was a minor, however, did still hold him liable because the course and education provided for his vocational and practical training were deemed necessaries. Next, in the case of the University of Malaya against Lee Min Chong, in 1964, the University of Malaya invited him to pursue his master's degrees overseas in Canada under the Colombo Plan. In this agreement, it was him and his two sureties. Laid down in this agreement was if he were to come back and the university told him to serve them, he shall do so for a period of not lesser than 5 years. And if he were to breach his term, him and his sureties will be liable to pay the demand sum of 5,000. Surely enough, upon his return, he was appointed as an assistant lecturer in the Faculty of Economics and Administration. The contract was supposed to be valid from the 6th of June 1966 to the 1st of January 1969. However, he was then promoted to a lecturer and that contract was set to be in effect starting from the 1st of January 1969. Lee declined his offer and gave his notice of intention to terminate his services with the university after his initial contract would end on the 1st of January 1969. The university then demanded the payment of 5,000 to be paid in according to the scholarship agreement as he had only been in service for 2.5 years and he was leaving without the university's consent. They brought the case to the Sessions Court, however, Lee claimed that there was no good consideration and he had already fulfilled the terms as he was in a service arrangement. The case was then dismissed, but upon appeal, the court held in the favour of the university and they were to be paid the demand sum of $5,000. The last authority for this issue is the case of De Francisco and Barnum. In this case, the defendant was an infant when she entered into an apprenticeship for 7 years to be taught stage dancing by the plaintiff. The contract stated that the infant should not accept any professional engagement and also not to marry during this term without the consent of her master. There were no stipulation that the master should provide dancing engagements for the infant or maintain her while she was unemployed. The infant later went on to enter a professional engagement to perform as a stage dancer for a third party. The plaintiff then brought an action against the defendant to enforce the contract and claim damages for its breach. The court held that the provisions for the contract was unreasonable and harsh and they could not be enforced against the defendant.
Thank you, Vince. Well, the scholarship agreement signed by Suhaimi as Yuna's guardian while she was a minor is legally binding and enforceable upon Yuna. Section 11 of Contract Act 1950 stated that the capacity to enter the contract a person should have reached the age of majority. The issue here, according to the question, whether Yuna has the capacity to enter into a contract which is made by her brother, because since Yuna was only 16 at the time of the contract has been made. According to Section 2 of the Age of Majority 1971, the majority of male and female shall please and determine within Malaysia at the age of 18, and every female attaining the age she be age of majority. General rule, the contract entered by minor is void. The reason of this rule is to prevent the minor against any consequences of its own action. According to Section 2 of the Age of Majority 1971, sounds like Yuna is a minor and the contract that has been entered is void. But is to advise Yuna that there is an exception to the general rule, and it is advised to refer Section 4 of Contract Amendment Act 1976 provides that no scholarship agreement should be invalidated on the ground that the person who entering the contract is a minor. So, Yuna is to advise, according to Section 2A of the Contract Amendment Act 1976, scholarship agreement means that any contract or agreement between an appropriate authority and any person with respect to any scholarship, award, brochure, loan, sponsorship, or appointment to a course of study, the provision of leave with or without pay, or any other facility, whether granted directly by the appropriate authority or by any other person or body or by any government outside Malaysia, for the purpose of education or learning of any description. Yuna is advised to refer the case of Government of Malaysia vs. Gurucharan, where in this case revolves around the enforceability of scholarship agreement. In this case, says the defense of lack of capacity of a minor to enter into a contract raised an action of breach of scholarship. High Court held the scholarship agreement is void. Looking into the case of Government of Malaysia vs. Gurucharan, it is advised that the scholarship agreement is void, but comparing to the case of University of Malaya vs. Lee Ming Chang, it sounds different. In the case of University of Malaya vs. Lee Ming Chang, this case involved a scholarship agreement where the University of Malaya sponsored a student named Lee Ming Chang to pursue his further studies abroad, with a condition of service. The scholarship agreement, including a clause requiring Lee Ming Chang to serve university for a specific period upon his return. But Lee Ming Chang refused to fulfill the service obligation after completing his studies. The issue raised here whether the scholarship agreement with its service obligation was legally enforceable. Lee Ming Chang argued that the service obligation lacked consideration and was invalid. So the court held, in this case, saying that the scholarship itself constitutes a valid consideration for the service obligation. The court reasoned that the scholarship provided to Lee Ming Chang with the opportunity to further his studies, which is a valuable benefit to him. Therefore, the service obligation was deemed to be enforceable. In the case of, if you refer in the case of University of Malaya of Lee Ming Chang, Nuna would have obliged to work with Idam's company for at least 5 years upon completing her studies, or paying him for what he has spent on her. But the question is here, above stated that Idam's company is facing some financial instability. Issue is it whether Yuna can choose not to work with Idam? Referring to the case of D. Francisco versus Barnum, stated that the provision of the contract is not reasonable and could not be enforced against the defendant, and the defendant has to pay the necessary because defendant has obtained the benefit. Therefore, we can conclude that Yuna does not have to work with Idam because since his company is facing a financial instability, but she has to pay what he has spent for her education. This is not because the agreement is valid, but she has obtained a benefit from Idam. So that's my conclusion here. Thank you.
So in conclusion, regarding to the first issue, there is a clear intention to create legal relationship between Adam and Suhaimin. This is demonstrated by Adam's actions such as purchasing a Ford Mustang and also formalizing the agreement in writing. This aligns with the principle established in the case of Carlo and Kabelik Mobile Company, where the company's action demonstrated an intention to be legally bound by its offer. Regarding to the second issue, the promise made by Adam to pay 500,000 ringgit to Suhaimin is supported by a valid consideration, as Suhaimin's marriage to Seri Devin benefits Adam's business, which follows the principle in Shadwell and Shadwell. Regarding to the third issue, Yuna cannot initiate a legal action against Adam for failing to honor the promise made to Suhaimin, as she is the third party of this contract. This is supported by the cases such as Kepong Prospecting and Schmidt and Shamugam and Frenzer, which this case affirms that only the parties to a contract can enforce its terms. Regarding to the fourth issue, the scholarship agreement signed by Suhaimin on behalf of his minor sister Yuna is enforceable under the exception provided by Section 4A of Contract Amendment Act. This aligns with the case of Government of Malaysia and Gurucharan Singh and others, which upheld the enforceability of scholarship agreements involving minors. However, Yuna's refusal to work with Adam due to the financial instability of his company can be justified under D. Francisco and Barnum, where the court found that an unreasonable provisions in a contract may not be enforceable. And that's all from our group. Thank you.